Good evening, respected officers from the states of Punjab, Haryana and UT Chandigarh. It is my privilege to address this esteemed gathering of the judicial officers under this crucial legislation. Respected officers, for the smooth functioning of this webinar, the mic of all the respected officers has been put on a mute mode. However, if any officer has any query regarding the topic, that can be typed in the window and the query shall be looked into by me after conclusion of webinar. Before I start the discussion on the topic, I would like to bring this to the notice of you all respected officers that as desired by the respected authorities of Chandigarh Judicial Academy, all the participants who are right now participating in this webinar shall have to prepare an assignment on topics which have been already sent on email to the respective districts, and the assignment shall be submitted by 2nd of June, that is Monday. So starting further, today we will explore the provisions of POCSO Act, its procedural requirements. From the perspective of special courts, we will delve into the sensitive trial practices, child-friendly approaches, and the imperative for timely adjudication. For juvenile justice boards, the focus will shift to how the Act harmonizes with the Juvenile Justice Act. We will begin with an overview of the POCSO Act, including its objectives and key provisions. This will be followed by the practical insights into the procedural aspects such as recording evidence, ensuring child-friendly proceedings, and safeguarding the child victim's right. Proceeding further, having a bird's eye view of the Act, the Protection of Children from the Sexual Offences Act 2012 was formulated in order to effectively address the issues, that is, sexual abuse and sexual exploitation of children. This Act provides for protection of children from the offences of sexual act, sexual harassment, and pornography. Taking into consideration what are the salient features of the POCSO Act, we first take into view the gender neutrality provided under the Act. The POCSO Act 2012 regards the best interest and welfare of both male and female child. This Act defines forms of sexual abuses which are different, maybe sexual assault to an aggravated sexual assault, and the circumstances when it becomes so. The salient features further include the stringent punishment which is provided according to the gravity of the offence, with the maximum punishment of lifelong imprisonment as well as fine. The Act further covers the child pornography, including the visual depiction of the sexual conduct of a child through video, digital, photograph, or computer-generated image, which might be indistinguishable from an actual child. When we talk about the scope of the POCSO Act, although this Act is a separate, self-contained legislation dealing with the offences against children, it cannot be construed as a complete code in itself. Various laws such as Bharatiya Nagarik Suraksha Sanhita, earlier Code of Criminal Procedure, Bharatiya Nyaya Sanhita, earlier IPC, Juvenile Justice Act 2015, and the IT Act often overlap or supplement the provisions of the POCSO Act. However, if there appears to be any inconsistency between other laws and the POCSO Act, then in accordance with the provisions of Section 42A of the POCSO Act shall prevail. So when we are discussing the provisions of the POCSO Act, the foremost important thing is the age of the child victim. Section 2B of the Act deals with the same, providing that a child means any person below the age of 18 years, irrespective of the gender, making it a gender-neutral provision. So POCSO Act explicitly protects all the individuals from the sexual offences, ensuring a uniform age threshold. The POCSO Act applies to any person below the age of 18 years. Establishing of the age of a victim is crucial in determining whether the case shall fall under the POCSO Act or not. Proper age determination ensures child-friendly procedures, victim protection, and adherence to correct legal provisions. At this stage, we must refer to a ruling of Honorable Supreme Court of India, that is Judicial versus State of Haryana, in the year 2013. Honorable Supreme Court has held that for the purpose of determining the age of a victim, the courts shall take into consideration the JJ Act rules, which provides that victim's age can be determined in view of these documents. And the documents are the date of birth certificate from the school or matriculation or any equivalent certificate from the concerned examination board. If these documents are not available, the birth certificate given by a corporation or municipal authority or a panchayat. In absence of these two, the age shall be determined by ossification test or any other latest medical age determination test. There is another Supreme Court, Honorable Supreme Court's authority of the year 2023, that is P. Yuva Prakash versus State, in which Honorable Supreme Court has discussed whether the school transfer certificate or the extracts of the admission certificate can be taken into consideration for the purpose of determining the age of the victim, and the answer has been given in negative by Honorable Supreme Court, holding that these were never part of Section 94 of the Juvenile Act. There was yet another interesting question arisen before Honorable Supreme Court, where there was a question that can a person whose mental age is below 18 years but his biological age is above 18 years, can such person fall within the category of child as described in the POCSO Act? The question was answered in negative by Honorable Supreme Court in Miss Era versus State in the year 2017 by Honorable Supreme Court. And the court had observed that the term age in Section 2B of the POCSO Act, it refers to the chronological or the biological age and not the mental age of the child. Now, having an overview of the POCSO Act, Chapter 2 of the Act comprises of Section 3 to 12 prescribing 5 different types of sexual offences, that is, penetrative sexual assault defined under Section 3, punishable under Section 4, aggravated penetrative sexual assault defined under Section 5 and punishable under Section 6, sexual assault, aggravated sexual assault, and sexual harassment. Section 13 to 15 of the POCSO lays down the offence of using a child for the purpose of pornography and prescribes for the punishment for the same. Further, the Act makes punishable the attempt and abatement of any offence prescribed therein. Now comes the most important topic of the Act. We have to now discuss about the procedures which have to be adopted. Firstly, taking up the point of a recording of the statement of a child. This is the most important thing to be done at different levels. As per the provisions of POCSO, there are 3 stages of recording of the statement of a child. Firstly, when the statement is recorded by the police official under Section 24 of the Act. Secondly, when the statement is recorded by the magistrate under Section 25 of the Act for the purposes of recording it under Section 183 of the BNSS, earlier 164 of the CRPC. Thirdly, the statement is recorded by the special court under Section 35 of the POCSO Act. So it is very important that the procedure and the measures which are prescribed under the POCSO Act should be followed while recording the statement of the child. As we all know, this Act is treated to be very important and very sensitive, as the officers shall be dealing with the child witness, and it is a very sensitive aspect, so it becomes incumbent on the part of the officer to follow the provisions of the law for the purpose of recording this statement or for applying any other procedure as mentioned in the Act. Let us see how the statement is to be recorded and what are the mandatories prescribed under the Act for the purpose of recording of the statement. Firstly, at the time of recording of statement of a child by the police, it can be recorded at the place of his residence or where he usually resides, at the place of his choice, as far as practical by a police women officer not below the rank of the sub-inspector. The police officer should not be in uniform whosoever is recording the statement of the child. The child must not at any point of time come in contact with the accused. No child should be detained in the police station in the night for any reason, and the identity of the child has to be protected. Now, when we are discussing about the recording of a statement by magistrate in view of the provisions of 164 CRPC, now 183 BNSF, the magistrate has to record the statement as such as it is spoken by the child. So far as the provision of Section 164 regarding permitting the presence of the advocate of accused has been done away with by way of proviso to Section 25. Now comes the most important part, when the special courts are recording the statement of the evidence of the child witness in the court. The Act provides that the evidence shall be recorded within a period of 1 month of the court taking cognizance of the offence. And in case there is any delay, a reason has to be specified by the special court. And the trial has to be completed within a year from the date of taking of the cognizance. So far as the recording of statement evidence of the child witness is concerned, there are yet another provisions of the Act giving the details how these statements have to be recorded, what measures have to be taken by the court while recording the statements. Before discussing that, we will discuss this important authority of Honorable Supreme Court. This is Smruti Tukaram versus State of Maharashtra 2019 Supreme Court, in which Honorable Supreme Court had passed guidelines that each High Court all over the country shall frame the guidelines for the purpose of recording of the statement of vulnerable witnesses in the cases before the courts. In this case, there were some instructions, there were some guidelines which were already framed by Honorable Delhi High Court, which were accepted by Honorable Supreme Court, and the guidelines were issued to the rest of the high courts. So in view of this judgment of Honorable Supreme Court of India, our Honorable Punjab and Haryana High Court had framed these guidelines for recording of evidence of vulnerable witnesses, which were circulated to all the officers for its compliance, and these guidelines are dated 7th February 2023. These guidelines deals with the recording of statement of vulnerable witnesses, which includes any child victim or a witness under the age of 18 years, any victim under the POCSO Act, any victim under the offences of 376, 1, 2, 376A, A, B, C, D, etc. of IPC, any person with disability of the Rights of Persons with Disabilities Act, person suffering from mental illness, a person having any threat perception. So they all are covered under the definition of the vulnerable witness, and the witnesses have to be examined as per the instructions and guidelines mentioned in the guidelines as circulated by Honorable Punjab and Haryana High Court. So coming back to the Act, there are some additional provisions, as I was already discussing, which have to be taken care of while recording the statement of the child witness. The magistrate or the police officer has to record the statement as such as spoken by the child in the presence of the parents of the child or any other person in whom the child has trust or confidence. While doing so, the magistrate or the police officer may take assistance of the translator or an interpreter. The magistrate or the police officer may also seek the assistance of special educator. The magistrate or police officer shall ensure the statement of child is recorded by audio, video, electronic means. Now, this is very important aspect which has to be dealt with by the special courts as well as the JGBs while they are dealing with the POCSO cases. The child-friendly procedures have to be adopted. The officers, the POCSO court, whenever they are recording the evidence, they have to create a child-friendly atmosphere by allowing a family member, guardian, a friend, or a relative in whom the child has a trust or confidence to be present in the court. The child's statement should be recorded in a child-friendly atmosphere. It has to be recorded as such as spoken by the child. It is the duty of the special court to ensure that child is not repeatedly called to testify in the court. The special courts shall conduct the trial in camera without revealing the identity of the child. I will be discussing the authorities of Honorable Supreme Court of India, whereby Honorable Supreme Court has given instructions, particularly on the point of the recording of the statement of the child, that it has to be concluded preferably on the same date without calling the witness repeatedly to testify in the court. And so far as the identity of the child is concerned, Honorable Supreme Court has been very serious about this fact and has directed by virtue of the judgments that the special courts shall take special care of the fact that the identity of the child is not disclosed in any manner. The Act further provides that aggressive questioning or character assassination of the child should not be done It shall be ensured by the court, and the court shall also ensure that dignity of the child is maintained. The courts shall ensure that the identity of the child is not disclosed. The services of professionals and experts can be taken in pre-trial and trial stage to assist the child in recording the evidence. It is also duty of the court to ensure that child is not exposed to the accused at any time in the trial. So as I told you, Honorable Supreme Court has passed instructions, has given observations regarding preserving the identity of the child victim. So we must understand what do we mean by the identity of the child victim. For this, we can refer to the explanation mentioned to section 33 subsection 7, which says that the identity of the child shall include the identity of child's family, school, relatives, neighborhood, and any other information by which the child identity of the child may be disclosed, revealed. So now this is the most important judgment of Honorable Supreme Court of India on the point of the disclosing of identity of the child. This is Nipun Saxena versus Union of India 2019 Supreme Court cases. In this, Honorable Supreme Court had laid down comprehensive directions to ensure the protection of the identity and dignity of the victims of the sexual offences. The court, Honorable Supreme Court, had emphasized that the identity of such victims must not be disclosed in any manner, directly or indirectly, through names, photographs, or any other material that may lead to their identification. So it becomes the duty of the court to ensure that the identity is not disclosed, not in the judgment and in the other proceedings of the judicial court. The Honorable Supreme Court has further directed that police officials should use pseudonyms while recording the statements and FIRs. In such cases, they are not put in the public domain. The court also barred disclosure of victim-related correspondence under the RTI Act. Honorable Supreme Court further affirmed that right to cross-examination for the accused. It called for such proceedings to be conducted with dignity and sensitivity. This point has to be ensured by the court while the cross-examination of the victim, that no such question is asked which is going to infringe her dignity and going to make her feel uncomfortable in the court. Further, in this very judgment, Honorable Supreme Court has reiterated the statutory mandate that the identity of the child must be kept confidential at all stages: investigation, trial, and reporting. So far as the duty of the police officer is concerned, the mandate is prescribed under section 24 subsection 5. Duty of the special court is mandate under section 33 subsection 7. It is also mandate that the proceeding shall be conducted in camera by the court. So this is how we can hide the identity of the victim. Whenever we are making a mention, whenever the courts are making the mention of the name of the victim, we can mention by using the first letter of the name instead of writing the whole name. If we have to refer to the mobile number, the last 4 or 3 digits can be mentioned and the remaining can be masked as cross, cross, cross. In the same manner, the mobile phone EMI or Instagram ID or WhatsApp number, anything which is referring to the victim, that can be masked, like putting cross, cross, cross and showing 1 or 2 numerics or alphanumerics of the identity. Even the name of the victim's father can also be masked. We can make a reference to the victim as H, daughter of father NS, son of TS, resident of village A. So that means the name of the village can also be mentioned as one of the initial alphabets of the name of the district or village. Even the name of the school of the victim has to be hidden, masked. We can always use the first alphabet of the name of the school of the victim. Even at the time of discussing the date of birth certificate of the victim, the court must not mention the full details, rather may mention that victim H, daughter of NS, resident of district K, and according to the birth certificate, birth date is so and so, and the place of birth is K. So we must refrain from mentioning the full details in view of the guidelines of Nipun Saxena versus Union of India passed by Honorable Supreme Court of India. So hiding of the identity of victim has to be there in the statement recorded during investigation before magistrate or during trial, in the charge, deposition of the witnesses, statement under section 313 CRPC wherever such mention has to be made, in the judgment. Now the most important point before the special courts is evaluating the child witness competencies. Like any other sexual crime, in POCSO 2, the possibility of having eyewitness is extremely rare. The child witness is only the sole witness to the crime. So in such circumstances, an important issue which may arise is whether the courts can rely on the sole testimony of the child victim in order to convict the accused. Since victims in the POCSO can be very young, and since evidence is often recorded after a considerable time, so there may be minor inconsistencies in the statement of the victim. Moreover, a child witness is also amenable to tutoring and inducement and is often prone to telling imaginative and exaggerated stories. Child witnesses, by reason of their tender age, are pliable witnesses, and hence their evidence needs to be scrutinized with extreme care and caution. Courts have to carefully balance the victim's right to justice with the accused's right to fair trial. It is important to refer to this judgment of Honorable Supreme Court, Ganesan versus State, where the same question had arisen before Honorable Supreme Court, when the question of whether reliance can be placed on the sole testimony of the child victim had come before the Honorable Apex Court. It has been held that, considering the object and purpose of the POCSO Act, when the evidence of the prosecutrix is reliable and trustworthy, conviction will stand even though another prosecution witnesses have turned hostile. So in this case, the accused had filed an appeal before Honorable Supreme Court on the ground that the mother of the prosecutrix has turned hostile and his conviction should be set aside. But Honorable Supreme Court had rejected his appeal and had held that the prosecutrix sole statement is reliable. Further, we have to refer to Honorable Supreme Court's judgment of Subodh Nath versus State of Tripura, in which it has been observed that in the deposition of the witnesses, there are always minor discrepancies due to normal errors of observation, loss of memory, mental disposition of the witness, and the like. So, unless therefore the discrepancies are material discrepancies, so as to create a reasonable doubt about the credibility of the witnesses, the court will not discard the evidence of the witnesses as such. Referring to another important judgment of Honorable Supreme Court recently passed in the year 2024, in Madhav Chandra versus State of Odisha, Honorable Supreme Court has observed that the victim who is called for the purpose of the deposition, mechanically would defeat the protective purposes of the POCSO Act. Whenever there is an application for the recall of witness under section 311, then the court has to be very vigilant. A child should not be repeatedly called to testify to protect them from the further trauma which the child had already undergone. Coming further to the presumptions under this Act, Section 29 and 30 of the Act are important provisions which provides for the presumption with regard to certain offences, and they are when the accused is said to have committed an offence under Section 3, 5, 7 or 9, where a person is prosecuted for committing, abetting or attempting any such offences, then the court shall presume that such person has committed, abetted or attempted the offence. So this is a reversal of burden of proof, strengthening the legal protection given to children and emphasizes the seriousness of the sexual offences against them. In the same manner, the court shall presume the existence of a mental state if in any prosecution for the offence under POCSO Act, the POCSO Act requires the culpable mental state on part of the accused. Then the special court shall presume the same. However, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to the act charged as an offence in that prosecution. So Section 29 and 30 of the POCSO does not actually relieve the prosecution of its burden to prove a case. However, the provisions only lessen the prosecution's burden by shifting the onus of proof to the accused. So as per the culpable mental state, it includes the intention to commit the act, motive behind the act, knowledge of the circumstances, belief in or reason to believe a particular fact. For this, it is important to discuss the ruling of Honorable Supreme Court in Just Rights for Children Alliance versus S. Harish, wherein Honorable Supreme Court had discussed 2 points: whether viewing of the child sexual exploitation and abuse material is punishable under Section 15 of the POCSO Act and under Section 67B of the IT Act. And second question was whether can Section 30 of the POCSO be invoked in the quashing petition. The Honorable Supreme Court held that mere viewing of material, such material, amounts to the constructive possession if the viewer exercises control over it, and failure to delete, destroy or report it is punishable even without actual sharing. It emphasized that Section 15 covers inchoate offences and does not require the possession at the time of FIR. The presumption of criminal intent under Section 30 applies even during the quashing proceedings, provided the foundational facts are established. So the courts automatically presume that the accused had required mental state for the offence. However, the accused can rebut this presumption by proving otherwise. The courts need to be convinced beyond reasonable doubt, a very high standard of proof. This applies to offences under POCSO, where intent or knowledge is a required element. However, statutory presumption under Section 29 cannot be read to mean that the prosecution version is to be treated as a gospel truth in every case. The presumption does not take away the essential duty of the court to analyze the evidence on record in light of the features of a particular case, for instance, patent absurdities or inherent infirmities in the prosecution version, or existence of entrenched enmity between the accused and the victim, giving rise to an irresistible inference of falsehood in the prosecution case, while determining whether accused has discharged his onus, established his innocence in the given facts of the case. So yet another important aspect of the POCSO Act is the alternative punishments as prescribed under Section 42. Wherever an act or omission constitutes an offence punishable under POCSO, and the other offences of 166A, 354A, B, C, D, 370, 370A, 75, 376, 376A, AB, B, C, D, DA, DB, 437 6E, 509 IPC, or Section 67B of IT Act. Then, notwithstanding anything contained in any other law for the time being imposed, the offender found guilty shall be liable for the punishment under POCSO or IPC, wherever the punishment which is greater in degree. This is very important. We will be discussing a judgment on this point as well. And it is further important to note that this act is not in derogation with any other law. However, in case there is any inconsistency, then the provisions of POCSO shall prevail. This is a very important judgment which has been delivered in the recent past in March 2025 by Honorable Supreme Court, Gyanendra versus State of UP, where the points for consideration before Honorable Supreme Court were whether the conviction under IPC and POCSO Act was justified given the overlapping provisions, whether the High Court was correct in enhancing the punishment to imprisonment for the remainder of the natural life without separate appeal for enhancement. So the observations or findings of the court were that court was justified in convicting the accused both under IPC and the POCSO. However, the law prescribing the greater punishment shall prevail as per the provisions of Section 42 of the POCSO Act. The court clarified that the distinction between 42 and 42A, that while dealing with the Section 42, it deals with the choice of punishment. Section 42A provides as an overriding effect to the POCSO in case of inconsistency. So, the court held that since the sections 376 subsection 2F and 376 subsection 2I of IPC prescribe a higher punishment than section 3 or 4 of POCSO, so conviction under IPC was justified as it was having a greater punishment. So now we have to deal with the yet another important aspect of the POCSO Act, that is the compensation to be paid to the victim. Section 33 subsection 8 of the Act empowers the special court to award compensation to the victim for their rehabilitation, medical care and psychological support. This compensation can be either interim or final. So far as the compensation point is concerned, as we already discussed the case law of Nipun Saxena, Honorable Supreme Court in this case has given the guidelines to the courts for the purpose of dispersal of the compensation to the victim. We will be discussing these guidelines as well in the coming slides. Rule 9 of the POCSO Rules 2020, which were earlier Rule 7 of the POCSO Rules 2012, and Section 33 subsection 8 of the POCSO Act deals with the compensation part, in which a duty has been cast upon the special court, which of its own or on the application filed by or on behalf of the child, pass an order for the interim compensation to meet the needs of the child for relief or rehabilitation at any stage after registration of FIR. And if interim injunction has been granted, that shall be adjusted with the final compensation to be paid at the final stage. Then further, the special court on its own or on an application recommend the award of compensation where accused is convicted or where the case ends in acquittal or discharge, the accused is not traced or identified. And in the opinion of special court, the child has suffered loss or injury as a result of that offense. Now, what factors have to be taken into consideration by the court, special court, while determining the compensation? These factors are the type of abuse, the gravity of offense, and the severity of the mental or physical harm caused to the child, the expenditure incurred or likely to be incurred on child's medical treatment, loss of educational opportunity as a consequence of the offense, loss of employment as a result of offense, the relationship of child to the offender, whether the abuse was single isolated incident or it was repeated, whether the child became pregnant, whether the child contracted any disease, any disability suffered by the child as a result of offense. So all these factors may be taken into consideration by the special court at the time of granting the compensation, which is to be paid by the state government from the victim compensation fund or other scheme may be established by it for the purposes of compensating and rehabilitating the victims under 357A of the CRPC. So the amount has to be dispersed by the government within 30 days of the receipt of order. So now this is important judgment as I have already discussed it, Nipun Saxena versus Union of India. The special court, upon the receipt of information as to commission of the offence, shall on its own or on the application of the victim make inquiry as to immediate needs of the child for relief and rehabilitation, and that court, if being satisfied that victim has suffered loss or injury due to commission of offence, shall award a reasonable compensation in favor of the victim. So Honorable Supreme Court has further held that the quantum of the compensation shall be fixed, taking into consideration the loss and the injuries suffered as per the factors laid down in the POCSO rules. The Honorable Supreme Court further held that interim or final compensation shall be paid by the state victim from the victim compensation fund. And as I have already discussed the rule, these are the same which have been reproduced by Honorable Supreme Court of India while giving the directions to the special courts. They have to deal with the compensation to be granted to the victims. Now, the courts have to be vigilant at the time of framing of charge, convicting without the charge, while granting the bail, acquitting or discharging, while admitting the evidence, while conducting the proceedings, while granting the compensation, while sentencing, deciding in the best interest of the child, complying with the statute, careful about the facts of the case, in the appreciation of evidence. While doing all these, the court has to take into consideration all the provisions which have been specified in the POCSO Act as well as in the judgments which have been given by Honorable Supreme Court of India. Now, it is important, as we all know, that there is a support person in the POCSO Act who is an individual appointed by the Child Welfare Committee to assist a child who is the victim of the sexual abuse throughout the legal and rehabilitation process. So Honorable Supreme Court of India, in the judgment that I shall be discussing, has also laid a stress on the point of the duties and the responsibilities of such support persons while taking into consideration their role in helping and guiding the child witnesses in going through the legal and the rehabilitation process. So what is the role of a support person which is prescribed under the rules? The support person, he plays a crucial role in ensuring the child's well-being. Their responsibilities include emotional and psychological support. They are supposed to help the child cope up with the trauma, emotional stress of abuse and legal proceedings. They have to do the counseling of the accused person, the victims. They have to liaison with the stakeholders, coordinating with the police, medical professionals, legal aid services, and child protection services. They have to explain the legal processes, simplifying the procedures and ensuring the child understands their rights and the steps involved in the legal process. They have to ensure the compliances and they have to report to the CWCs in this regard. So this is the judgment of Honorable Supreme Court. This is Bachpan Bachao Andolan versus Union of India. In the year 2023, Honorable Supreme Court has emphasized the importance of support persons for victims under the POCSO Act and had issued the guidelines specifying that a support person is to provide information, emotional and psychological support, practical assistance, which are often crucial to the recovery of the child. This can go a long way in helping them cope with the aftermath of the crime and with the strain of the criminal proceedings. In many ways, a support person acts as a guardian of the child. This is what the Honorable Supreme Court has observed. So the Supreme Court also says that the support person is responsible for accompanying the child during the recording of statement, medical examination, depositions, and assist in all other interactions of the investigation, pre-trial or trial stage. So it is further important when the accused is in a POCSO case is a juvenile, the JJB has the exclusive jurisdiction to handle the case as per the JJ Act. The trial shall be conducted in accordance with the procedural safeguards and the principles laid down in the JJ Act, focusing on the rehabilitation and reintegration rather than the punitive measures. The substantive provisions of the POCSO Act regarding the definition of the offences and their classifications are applicable. However, the procedural aspects of POCSO Act, such as relating to the powers of the special court, sentencing, or certain penalties are not applicable in the proceedings before the JJB because JJ Act provides a separate framework for the juveniles. POCSO rules emphasizes the child-friendly and sensitive approach to handling cases which align with the principles of the JJ Act. Thus, procedural principles of the POCSO Act, such as recording evidence in camera or ensuring dignity of the victims, can guide the JJB proceedings. The focus remains on ensuring justice for victims while adhering to rehabilitative object of the JJ Act for the juvenile in conflict with law. So we will discuss few more authorities of the Supreme Court of India, how the matters have been dealt with by Honorable Supreme Court at the highest level. This is an important judgment, Attorney General of India versus Satish, delivered in the year 2021, in which Honorable Supreme Court observed that the most important ingredient for constituting the offence of sexual assault under Section 7 is the sexual intent and not the skin-to-skin contact with the child. The Supreme Court observed that the act of touching any sexual part of the body of the child with the sexual intent or any other act involving physical contact with the sexual intent could not be trivialized or held insignificant or peripheral so as to exclude such act from the purview of the sexual assault under Section 7. The Honorable Supreme Court further observed that restricting the interpretation of the words touch or physical contact to skin contact would not only be a narrow and pandemic interpretation of the provisions of Section 7, but it would lead to an absurd interpretation of said provision. The very object of enacting the POCSO Act is to protect the children from the sexual abuse, and Honorable Supreme Court held that if such a narrow interpretation is accepted, it would lead to a very detrimental situation, frustrating the very object, in as much as the case of touching the sexual or non-sexual part of the child, which is done through the sexual intent, will certainly come within the purview of Section 7. Referring to the further judgment of Honorable Supreme Court, Bijoy versus State of West Bengal, where the proposition before Honorable Supreme Court was whether delay in filing FIR and sole testimony of the victim can sustain conviction under POCSO. The Honorable Supreme Court upheld the conviction, ruling that victims' consistent testimony and plausible explanation for delay in lodging FIR are credible and are sufficient for conviction. So these kind of rulings of Honorable Supreme Court are guidelines for the courts for deciding the matters which are pending before the courts. There is another authority of the Honorable Supreme Court in right to privacy of adolescents suo motu writ petition, whereby Honorable Supreme Court held that in view of clause 6.3 in section 375 of IPC, penetrative intercourse with a woman under the 18 years of age with or without her consent constitutes an offence of rape. Therefore, whether such offence arises from a romantic relationship is absolutely irrelevant. How can an act that is an offence punishable under the POCSO be termed as a romantic relationship? Honorable Supreme Court had observed this. So there are further certain guidelines to the mandatory reporting. Whenever there is any such offence, as per the section 19 of the POCSO Act, there has to be mandatory reporting of the cases of the sexual abuse to the law enforcement and authorities, and applies to everyone including parents, doctors and school personnel. And failure to report such a suspicion of the child abuse is itself an offence under the Act. The legislation further makes it clear that reporting obligation exists whether the information was acquired through the discharge of professional duties or within a confidential relationship. So far as the child-friendly procedures which are adopted by the courts are concerned, in the same manner, the child-friendly procedures have been prescribed to be followed by the special juvenile police unit or the local police as well as the magistrate. They all are also supposed to ensure that there is child-friendly procedure adopted. Anyone including a child can report an offence to the special juvenile police unit. All individuals, institutions, including schools, colleges, etc., are under the obligation to report the cases of child abuse as soon as they came to know about it. So the Act further provides for the care and protection to be given to the child by SJPU. They make immediate arrangements to take the child to the nearest hospital for the medical examination. A duty has been cast upon the police to report the matter within 24 hours to the Child Welfare Committee and the special courts. The Women Sub-Inspector shall record the child's statement, preferably at the residence of the child or at the place where he or she usually resides. This is what we have already discussed, that the police must not be in the uniform, and it has to be ensured that the victim does not come in contact with the accused at any point of time. So this is a flow chart where the child is victim of a sexual abuse. Then there has to be reporting of the incident to the local police. There has to be a recording of the statement by SJPU police within 24 hours. The child has to be taken to the shelter home. The child has to be taken for the medical examination. There has to be a recording of the statement by the magistrate. Then CWC has to decide regarding the stay of the child. Then special courts has to be child friendly. When the CWC is deciding about the stay, the restoration can be made to family, guardian, or a fit person. It can be made to children homes or shelter homes. They may go for counseling and support persons. The child has to be given help or interpreter, translator wherever required. It has to be seen that measures are taken to protect the victim from coming face to face in contact with each other. The special courts has to take care of the victim compensation part, and prosecution in such cases has to be by special public prosecutors. So as I have already informed in the beginning, the topics have been already sent by the authorities of the Chandigarh Judicial Academy to the email ID of respective districts, and officers are requested to prepare the study material of approximately 10 pages and send the same through the email at the Chandigarh Judicial Academy as per the instructions of the authorities by Monday, that is 2nd of June 2025. So that's all for today's discussion. As I am not able to find out any query by anyone. If anyone has any query, he or she is at liberty to please come up with the query. So while concluding, I would say, as judicial officers, each of you carries the profound responsibility of interpreting and applying this law in a manner that not only upholds its legal mandates, but also ensures the emotional and psychological well-being of the children involved. Your work directly contributes to restoring faith in the justice system and protecting the future of our society. I extend my heartfelt thanks to each of you for your attention and thoughtful participation. Thank you once again, and I wish you all the very best in your endeavors to uphold justice under this important legislation. Thank you.